As your case begins, you may hear your lawyer talk about discovery, and you may wonder, what is discovery? Because if you just hear the term, you may think it's like some, chest of gold sitting there you're about to get. Truth is, in a divorce case, a discovery that's really well done can lead to a chest of gold sometimes, as far as the things we might get from the other side that are going to be so important to winning your case. There are all kinds of questions that are going to be asked, documents that have to be produced, and things like that we're going to work through over the course of your case to make sure we gather all the information in advance so we know what the other side is going to use, we know what we need to use, we know what we're going to be able to get to prove your case. The discovery process is extremely important to prepare for the trial we're going to have at one point in the future in your case. Discovery is used to gather a large range of information in your case. A lot of this is going to be financial. Some of it may be about people that you have been involved with romantically, sexually, or physically. Sometimes it may be about gifts you've given to people. Sometimes it's going to be about even whether you admit or deny you've been charged with certain crimes. Sometimes it's going to be request to produce financial documents or request to produce even medical or health records. So those kind of things are what we're going to gather in the discovery process that really helps us be able to prepare your case for the trial that's going to happen. There are three common types of discovery requests that happen in the divorce case. One's called request for production, then we have interrogatories, and then we have requests for admissions. Each of those are a little bit different. On the admissions first, you might get a list of questions that ask you to either admit or deny certain things. Now, I know that everything is not black and white. It's not just simple admit or deny sometimes, and you might want to explain an answer. Well, if the question only is admit or deny that this happened, you just got to admit or deny that this happened. In a hearing, you may have a chance later on to give more information, or maybe in response to other discovery requests. For instance, in the interrogatories, they're going to ask you questions, and you've got to answer the questions under oath and give truthful answers to these questions. They're going to seem really intrusive, but discovery is a lawful part of this whole process, and the other side has a right to ask these questions. And then the third type we typically use are called requests for production. These may be asking you to produce evidence or exhibits you're going to use in the trial. Sometimes it might be to produce bank statements or your mental health records or even records about the children's education or something like that if your kids are at issue in this case. So those are three common types of discovery that we will issue in a divorce case. Sometimes there are so many requests that come in, you may think, you know what, this is none of their stinking business, or I don't even know how to gather these things. At some point, the other side might make a motion called a motion to compel that gets filed with the court, asking the court to require you to provide answers. Before you're compelled, we have a right to object to those. But here's what you need to remember. As your lawyers, we need to know everything. And so when we send you your discovery request, we need you to answer every single one of those. And honestly, we're the ones with a law degree who are trained in how to respond to these things. Please leave it to your attorneys to decide what we object to and what we answer. I need you to answer all of them and give me all the information. Then I'm not going to turn over anything or produce documents or answer questions that are going to hurt your case unless the court requires us to do so. So give your lawyer everything and let them make the decision about what to object to and what not to object to. And then, if a motion to compel or a discovery motion is filed later on, the court may still require you to give some answers, but if your lawyer already has those in advance, it's going to speed the process for you. Some lawyers who bill people by the hour do tons of discovery just because it's a really easy way to run up that clock. In our office, we only do flat fee billing, so you know up front what your investment will be in your case, and no matter what happens, you don't run up a bigger bill the longer it goes on. So we try to use discovery in a very strategic way because I don't need to just ask a million questions just to get it out there. I want to ask things that help us build the best case we can for you, because discovery really should be have a point to it. We want to be able to ask questions. If it's admissions, we need for them to admit or deny that they were arrested for a DUI on December 31st, 2024. Or we need to ask them to admit or deny they've ever had a sexual relationship with Sally Smith, whoever it is. Or we may need to ask them to produce certain things that are going to help us build our case. If we know they've done some shifting around of their finances, we need to ask them to produce all their financial records for the last 5 years. Or maybe we know that they have contracted an STD because they were involved in a sexual relationship with somebody else. We need to ask them to produce their health records for us. All of these things are important, but discovery, in our view, should have a very strategic purpose to help you prepare the strongest case you can to present to the judge in your divorce case. So if you have questions about discovery in your case, or whether things are relevant, or whether things should be produced or objected to, call somebody who knows. Call our office today. We can help you through your discovery process.